Hi, good afternoon, everybody. Vansh, are you here as well?
Vishwam, I am on the ground.
Okay. Do we have everybody here from Hamad bin Khalifa University and Middlesex University, Dubai? I think Hamad bin Khalifa is in probably the earlier rounds, is it?
Yes, that's right. We're also waiting for Anastasia. She just joined.
Yeah, I think Anastasia is here. Hi, Anastasia, can you hear us?
Okay. Yes.
I think Khalid is here as well.
Hello, yes, I can hear you.
Good afternoon, everyone. Do we have all participants from Middlesex University, Dubai here?
Yes, we do have all of them here.
All right. And do we have all the participants from Hamad bin Khalifa University? Okay, maybe if we could just wait it out for a couple of more minutes. The previous rounds is spilling over, so I guess the remaining participants should be joining in just a couple of minutes. Thank you for your patience.
Hello, hi everyone. Am I audible?
Yes, you are.
Yes, so I believe both teams are already present, correct?
I think so. Middlesex is present.
Yes, Middlesex University Dubai 1 will be acting as defendant, and Hamad bin Khalifa University is present. I see HBKU claimant on the list of participants. Can we get confirmation, please, if you are present?
You'll have to unmute yourself, the whoever is named themselves HPKU claimant. There is a button, there is a cluster of 4 buttons at the bottom. The first one from the left. Yes.
Good afternoon. We are with you and we apologize for the delay.
No worries. I appreciate that there were some technical issues with the last round, but hopefully this round will be better. I think we have Anastasia on the call, and there should be two other judges. So we'll wait for maybe 2 more minutes. If they don't arrive, I think we can proceed with the round. Is that all right?
That's okay with us. Thank you.
Yes, it's okay
Perfect.
with us too.
Thank you very much. Hi all. We are yet to hear from the two other judges, but I think we are safe to start the round now, being conscious of time. Can I request the judge and the participants to please turn on their cameras? All right. Anastasia, can you please turn on your camera as well, please?
Yeah, just a sec.
All right. And Hamad bin Khalifa University is on. Perfect. All right, I think we are good to start this round. And if I'm correct, I believe that Hamad bin Khalifa University is acting as claimant and Middlesex University Dubai 1 is acting as defendant. We can start off the rounds with just the participants introducing themselves, their names, and their roles, and then over to you, Anastasia, to judge the round.
Good afternoon, everyone. My name is Cristina Altalatini, and I'm representing the claimant. And my colleague, Karim Hazal, he is co-counsel for claimant. Thank you, and very nice to be here. Nice to meet you.
Good afternoon, guys. I am Sheikha Rania, and I appear as the senior counsel for the defendant, along with my junior counsel, Christine. It's really nice to meet you. It's really nice to be here.
Good afternoon. My name is Christine Matthew, and I appear as junior counsel for the defendant, and it's really nice to meet you too.
Today, before me, I am considering the matter between Artemis Astathea as a claimant and Solar Dream Incorporated as a defendant. I have been placed the following documents before me. The defendant's skeleton argument. I was notified by the case management office that the revised bundle was submitted 6 days late. Therefore, unfortunately, I need to disregard it because it was late, and I will be sticking to the first version of the skeleton. Also, I was given the claimant skeleton argument. During the round of today's hearing, we will be considering the submissions in the following order. First, the senior claimant of the claimant will be producing the claim. Further, senior defendant will be presenting the defense of to claim. Further, senior claimant will be presenting the rebuttal relating to the claim. Further, senior defendant will be presenting the surrebuttal relating to the rebuttal of the claim. I believe you know the order, so I will not be continuing. So if I may request the senior claimant to proceed with the presentation of the claim.
Your Honor, opposing counsels, once again, good afternoon. And my name is Cristina Altalatini. Along with my co-counsel Karim Hazal, we are representing the claimant in this dispute, Ms. Artemis Astrotea. The claimant respectfully requests that the court accept her claim while dismissing the defendant's counterclaim due to defendant's failure to fulfill their contractual obligations and their negligence in ensuring the safety of passengers during the Stars Align Space Yoga retreat. I will begin by giving the esteemed court an overview of the dispute. Your Honor, this is a case about broken dreams and missing out on the adventure of a lifetime. The claimant, Ms. Artemis Astrotea, a popular YouTuber with 27.3 million subscribers, purchased a very expensive spaceflight ticket for the Stars Align retreat, organized by the defendant, Solar Dream Incorporated. Ms. Artemis' goal was to film a unique space yoga series to cure her chronic headaches while also creating viral content. Uh, she paid an astronomical ticket price, traveled a long journey from Montreal to Dubai, underwent medical evaluations, and filled out required health forms prior to the spaceflight. To the best of her belief, she only suffered from chronic headaches, which were not of a traditional medical nature, but rather just a misalignment of her neurons with the Earth's gravitational field. Before the spaceflight, given the recent outbreak of a new COVID 19 variant, Solar Dream conducted tests on all the passengers. Unfortunately, they only relied on the lateral flow test and did not wait for the more definitive PCR test. Having already invested 7.5 million US dollars in this trip, the claimant was in no place to refuse departure and lose her money. Although Ms. Artemis passed a lateral flow test before launch, her PCR test later came back positive for COVID 19. This resulted in an outbreak among all passengers and crew during the retreat, forcing an early return to Earth. Your Honor, the defendant's inadequate safety protocols prevented the claimant from receiving the services she paid for and caused significant losses in her earnings and her reputation. Solar Dream's decision to proceed with the flight without PCR results and their failure to protect passengers led to the claimant's inability to film and the subsequent embarrassment of failing to fulfill her advertised plans. Moreover, Solar Dream are alleging that her non-disclosure of her chronic headaches breached the spaceflight agreement. They are also alleging that Ms. Artemis caused them reputational damage due to the widespread cancellations for future retreats, although this reputational damage was the company's fault due to their inadequate safety protocols and failure to appropriately respond to a global health threat that was well known by everyone. In light of the above, on behalf of the claimant, we will respectfully submit the following main arguments. First, the defendant is liable in tort and for breach of contract. The defendant is liable in tort for breaching their duty of care because they failed to do everything reasonably practicable to minimize the safety risk of space travel, and the defendant cannot be exempted from liability because the risk assumed by the claimant is different from the risk the defendant created, which was completely avoidable. Also, the defendant, yes.
Please continue.
Also, the defendant is liable for breach of contract because they failed to comply with their obligations to take actions to mitigate safety risks, such as delaying space flight departure. Our second argument is that the claimant is not in breach of contract for non-disclosure of her chronic headache because in her honest belief, those were not of a traditional medical nature and her non-disclosure was reasonable in the circumstances. Alternatively, if the court finds that the non-disclosure of her symptoms was a non-performance, then the claimant still did not breach the agreement because it was not a fundamental breach. I will now elaborate on the first main argument, and I will speak for approximately 15 minutes, while my co-counsel, Karim Kazal, will later be addressing the second main argument, and he will also speak for approximately 15 minutes. Now, with regards to the duty of care, Your Honor, the defendant is liable under tort for breach of duty of this care. Solar Dream owed Ms. Artemis a high standard of care due to the inherent risks associated with space travel. Solar Dream, as a responsible spaceflight operator, failed to meet this obligation. Under the DIFC Law of Obligations, Article 17, liability for negligence is established if the defendant owns a duty of care to the claimant, the defendant breaches this duty of care, and the defendant's acts or omissions in breach of his duty of care to the claimant cause losses to the claimant. Under Article 18, a duty of care is established when it is reasonably foreseeable that the defendant's acts or omissions could cause loss to the claimant, when the relationship between the defendant and the claimant is sufficiently proximate for a duty of care to exist, and thirdly, when it is fair, just, and reasonable in the circumstances that the defendant should owe the claimant a duty of care. Under Article 21 of the same DIFC Law of Obligations, a breach of duty of care is established when a defendant failed to exercise reasonable care to avoid causing loss to the claimant, having regard to both the probability and the likely seriousness and the loss. Reasonable care is defined
You
by
have
the law.
mentioned the agreement made between the claimant and the defendant. Are there any obligations of the defendant pertaining to, like, from which we can conclude that there was also a duty of care?
So the duty of care, Your Honor, will not necessarily arise from the contractual obligations, but rather under tort law. Because this duty of care is established based on the principles, the legal principles I have just mentioned above, the claimant, as a customer who paid a significant price for the ticket, the Solar Dream Incorporated, the defendant, have a duty to protect her safety during the space flight.
But you have noticed, you have mentioned to me that the duty is arising, and you are currently making a strong argument pertaining to the tort, whereby you were talking about that there have been the contract made between the claimant and the defendant. So why you are trying to make the argument that the liability is arising out of tort rather than from the contract in this particular situation?
Your Honor, thank you. I completely understand your question. And the argument is we are making is that there is a liability both under tort and a liability for breach of contract. We have started with the tort liability. And although in the Section 4 of the agreement between the parties, the defendant tried to escape some of these liabilities, mainly based on the inherent risks associated with space travel. Solar Dream still has an obligation to minimize those risks within reasonable limits. So I would point you to clause 4.1 of the agreement that recognizes that despite the space flight operators' best efforts, certain risks may be unavoidable. However, Your Honor, the defendant's negligence in failing to confirm the results of the PCR test before launching created an entirely avoidable risk. The defendant could have postponed the flight, a decision well within their rights under the contractual provisions, and thereby ensure proper safety protocols were observed. Furthermore, Your Honor, because you're inquiring about the tort liability, the defendant cannot rely on exclusion of liability as a defense under Article 59 of the DIC Law of Obligations. Article 17 of this law concerning implied terms in contracts and unfair terms states that a supplier providing a service as part of their business has an implied obligation to carry out that service with reasonable care and skill. Solar Dream, Your Honor, failed to conduct proper safety checks prior to the departure, therefore is falling short of this standard. And if I...
Thank you.
Thank you very much. If I may continue, Your Honor, regarding establishing the contractual obligations to delay the launch were outlined in clauses 3.2, 3.3, and 5.4 of the spaceflight agreement. So
Please, 3.2?
3.2,
Yes.
3. And 5.4. All of this
5.4. 5.4.
So these clauses would have allowed the defendant to delay the launch and therefore prevent the health incident that unfortunately happened in space. By prematurely launching without adequate safeguards, they exposed all the passengers, including Ms. Artemis, to unnecessary and avoidable health risks. So I re-emphasize, Your Honors, the risks were both unnecessary and completely avoidable. Therefore, Your Honor, we submit that Solar Dream cannot absolve itself of liability under tort because its actions went beyond the risks that participants inherently assume when embarking on such journeys. The defendant's negligence directly exposed the claimant to avoidable harm that reasonable diligence could have prevented. We respectfully request that this court hold Solar Dream accountable for the damages caused by its failure to fulfill its duty of care in recognition of the significant personal and professional toll this breach has taken on Ms. Artemis. Let this judgment reaffirm that companies operating in such high-risk domains have a duty to protect their clients and meet the reasonable expectations of safety and care that such ventures demand. If you may allow, Your Honor, I will continue with making my argument for the breach of contract.
Yes, please.
The defendant is liable for breach of contract because Solar Dream breached its contractual obligations by failing to take appropriate actions to mitigate safety risks, such as delaying the departure in accordance with Clause 1.1 of the Space Flight Agreement that allowed this delay. Article 59 of the DIFC contract law mandates that parties exercise their best efforts to fulfill their contractual obligations. Article 60 continues by broadening this duty and considering how the obligation is expressed within the contract, the price, the associated risks, as well as the relative influence of each party. Given the substantial ticket price and the inherent risks associated with space travel, a high duty of best efforts was reasonably expected of the defendant, especially as Solar Dream had already operated 4 flights in total, each with 10 passengers, since it began operations 3 years ago. On the other hand, the claimant, Ms. Artemis, had minimal influence over the space flight's conduct and could only rely on the conditions and safety precautions imposed by Solar Dream for all its travelers alike. The defendant therefore failed to meet their duty of best efforts when they ignored the absence of the PCR test results and the subsequent departure of all passengers. Instead of delaying the departure until another launch window could be secured, Solar Dream proceeded with the flight, prioritizing expediency over the safety of its passengers. The failure to uphold their best efforts obligation and comply with Clause 1.1 of the agreement led to avoidable health risk for Ms. Artemis, ultimately preventing her from participating in retreat as planned and fulfilling her commitments. We respectfully request that this court hold Solar Dream accountable for their failure to meet their contractual obligations and for the resultant damages suffered by the claimant. In conclusion, Your Honor, this is a case about broken dreams and missing out on the adventure of a lifetime. Artemis Astrotea embarked on the Stars Align retreat with boundless hope, investing not just her money, but her very spirit into what she believed would be a transformative journey. She envisioned healing her chronic headaches through the unparalleled serenity of low gravity yoga while sharing this historic moment with her millions of followers on YouTube. For years, she tirelessly built a brand on the idea that drawing cosmic energy could bring peace, joy, and health. This retreat was to be the culmination of her passion and dedication, offering her audience something truly unique, the first ever space travel yoga series. Instead, Solar Dream's failure to implement adequate safety protocols shattered this dream, leaving Miss Artemis stranded in the isolation of the floating haven station, unable to participate in the retreat or capture the viral content she promised her audience. The personal toll was immense, but the professional fallout was even more devastating. Her plans were widely publicized, and her inability to deliver not only resulted in significant financial losses, but also brought her embarrassment in front of her global audience. Your Honors, this is not just a matter of business agreements or medical oversight, it's about trust. Artemis trusted Solar Dream to safeguard her health and fulfill the commitments they made to her. In failing to do so, they robbed her of the adventure of a lifetime and left her dreams in ruins. Miss Artemis seeks your judgment not only to hold Solar Dream accountable, but also to find justice for the lost opportunity, the dashed dreams, and the financial and emotional costs of this once in a lifetime failure. To conclude, Your Honor, the claimant respectfully requests that this court find the defendant liable for negligence and breach of contract, awarding the claimant 15 million US dollars in damages. Thank you very much for your time and consideration. I have finished my time. Thank you.
Thank you for your submissions. I would like to point out your argument pertaining to clause 5.4 of the contract, where you said that Miss Artemis can postpone the flight. But is it following from the clause 5.4? If you can please address it again.
So, Your Honor, Clause 5.4 states that in the event of a change in the passenger's medical condition, that, in the reasonable opinion of the spaceflight operator, may affect their ability to safely participate in the spaceflight, the spaceflight operator reserves the right to deny boarding to the passenger, subject to clauses 3.3, which I have mentioned before. So this clause, Your Honor, mentions that it is possible to delay the flight, but also deny boarding and, of course, return the price of the ticket.
Yes, but does Miss Artemis have the right, according to the contract, to either terminate the contract or to postpone the flight? Because from your argument, it followed that based on the clause 5.4, she has such right. So if we
So,
will
Your
just if you can point out in the agreement where I can find it.
So, Your Honor, maybe there was a slight misunderstanding because my submission was that the defendant had the option and actually had an obligation to delay the flight if it felt that it's not safe, if it felt that maybe the weather conditions were not suitable, or as in our case that there was a pandemic and they had to wait for PCR tests for all the passengers. So that was my submission, Your Honor, not that the claimant had the option to delay the flight. The defendant had the option and actually an obligation.
And not to delay, to probably reschedule or delay or somehow to affect the launching date. That was my question. But okay, yeah, thank you for your submissions.
Thank you very much.
May I please request the senior defendant to present a defense to the claim?
Yes, Your Honor. May it please the court, I am Sheikha Rania and I appear as the senior counsel for the defendant, Solar Dream Incorporation, along with my junior counsel, Christine Matthew, in the matters of Atramis Astrothea and Solar Dream Incorporation under the DIFC Court of Space. Your Honor, in response to the claimant's submission, I will address the first ground of claim and attempt to convince this court that the defendant was not negligent in their conduct. And I ask the court to allow the defendant to deny any liability arising from negligence, breach of contract, and loss of earnings. My junior counsel will be dealing with the counterclaim against the claimant for the breach of contract by failing to make disclosure about her health condition and loss of reputation from the claimant's conduct. I will be speaking for 17 minutes, and my co counsel will be speaking for 17 minutes, respectfully reserving 10 minutes for the rebuttal. In support of these issues, I shall be making two submissions, Your Honor. Firstly, I will try to convince the court that the defendant was not negligent in delivering the services. Secondly, the defendant delivered the service with utmost care and standards. May I proceed with my first submission, Your Honor?
Yes, please proceed.
Thank you, Your Honor. Your Honor, the defendant cannot be held liable for negligence as they have acted within the reasonable industrial standards of care, and there is no causation between the defendant's conduct and the loss incurred by the claimant. Firstly, according to Article 21 of the DIFC Law of Obligations, the defendant has acted within the bounds of the industrial standard of care by making sure that the spaceflight participants were fit to fly. Here, from the facts, it could be inferred that no other passenger on board showed any symptoms and the lateral flow test reflected negative. This means that the flight operator would have reasonably believed that all the conditions to safely launch were met. As soon as the claimant's test was identified to be positive, the crew quarantined her from the rest of the participants. Subsequently, the operator acted within the reasonable standard of care to prevent the further spreading of the disease. Your Honor, secondly, according to Article 82 of the DIFC contract law, the outbreak of COVID 19 on board and early return to Earth was beyond the defendant's control. I argue that this emergency situation must be considered a force majeure event under Article 82, which states that, except with respect to the mere obligation to pay, non performance by a party is excused if the party proves that non performance was due to an impediment beyond its control, and that it could not have reasonably be expected to take the impediment into account at the time of the conclusion of the contract, or to have avoid or overcome its consequences. Your Honor, it is unsure when the claimant actually contracted the COVID-19 virus. Moreover, the claimant, by not disclosing her discomfort and headaches, significantly impacted her own experience of the program where the defendants were unaware of such conditions. The defendants did everything in their control to ensure that the passengers were fit to fly. This can be highlighted by the fact that, in addition to the procedural checkups, precautionary cursory examination and COVID tests were conducted. Moreover, the launch was initiated on a medical professional's advice. It is beyond the defendant's capabilities to control the conditions relating to COVID 19. Therefore, it is unforeseeable that the situation on the board turned worse and the defendant had no choice but to return to Earth. Hence, I argue that the outbreak of COVID 19 on board and early return to Earth is an appropriate response and qualifies as a force majeure event. Your Honor, moreover, I contend that in accordance with Article 11 of DIFC Law of Obligations, the defendant ceases to be the primary cause of the claimant's loss. Here, the claimant's loss cannot be directly linked to the defendant's conduct because of the intervening force majeure event, that is the COVID 19 infection. This is further in unforeseeable circumstances beyond the defendant's control. Hence, the force majeure event is the supervening cause of Artemis' loss. Secondly, according to Article 10, Subarticle 1 of DIFC Law of Obligation, to establish negligence, the claimant must show that, but for the defendant's conduct, she would have not suffered the loss, and the defendant's conduct was the substantial cause of her loss. According to Article 10, the claimant cannot claim for losses as the defendant is not the substantial cause of a loss. This shift in causation arises due to the force majeure event, which effectively alters the defendant's role as a substantial cause of a loss. As a result, I contend that the defendant's liability, as stipulated in Article 17, Subarticle 2 of DIFC Law of Obligation, should be reduced by degree to which the claimant's negligent action or omission contributed their own loss. Your Honor, here the claimant's headache could have not been taken into consideration by the spaceflight operator, as she did not inform the operator and the medical teams of her headaches and discomfort. This is an unforeseeable.
Sorry,
Yes, Your Honor.
any according to the agreement, like according to what should have disclosed the same conditions? Is it written according to the contract? Is it written according to the law? Like according to what she should
It
have?
is according to the contract, and I will be dealing with that later in my submission, Your Honor.
Okay, please proceed.
Thank you, Your Honor. This is an unforeseeable circumstances beyond the operator's control. Therefore, regardless of delays in the PCR test result, the claimant risked her own health by not disclosing her discomfort. In order to prove this point, I would like to draw your Honor's attention to the United States Supreme Court decision in Air France versus Sachs, reported in the 470th volume of 1985 US report on page number 392. Would you benefit from a brief overview of the case, Your Honor?
Yes, please.
Thank you, Your Honor. In Air France and Sachs, Valkyrie Sachs claimed Air France was liable for her hearing loss after a flight from Paris to Los Angeles, alleging a negligent maintenance of the jetliner's pressurization system. The Air France moved for a summary judgment, arguing that Sachs could not prove her injury was caused by an accident under the Warsaw Convention. The Supreme Court held that the liability under Article 17 arises only if the passenger injury is caused by an unexpected, unusual event or an external to the passenger and not by the passenger's internal reaction to normal aircraft operation. This case provided that the liability under Article 17 of Warsaw Convention arises only if the passenger's injury is caused by an unexpected or unusual event or happening that is external to the passenger and not where the injury results from the passenger's own internal reaction to the usual, normal, and expected operation of the spaceflight. Consequently, the claimant contributed to her own loss by not disclosing any symptoms, which would have helped the defendant mitigate the COVID situation better. As a result, the defendant conduct is no longer the substantial cause of the claimant's loss. Here, I urge the court to consider that the defendant is in no circumstances the cause of the claimant's harm, if any. Therefore, the defendant is not liable for negligence towards the claimant.
Can you please outline the facts of the cited case, how they are relevant to the current case? So why I should take it into consideration?
Your Honor, you should take it into consideration because it talks about the causation towards the injury, not in the injury itself suffered by the claimant. Injury here can be any losses or the infection of COVID-19. So
Any
the
other
argument
relevant
is
facts that
that
why I should be taking it into consideration?
yes, Your Honor, you should take it into consideration because the cause for the claimant's injury over here is not the defendant. It's an external outside cause that caused her to have the COVID infection, which affected her participation later on in the program.
Okay.
May I continue with my speech, Your Honor?
Yes, please.
Thank you, Your Honor. Lastly, even if the court were to find the defendants liable for negligence under Article 17 of DIFC Law of Obligation, I contend that the claimant is only entitled to 1 million USD according to Clause 4.5 of the agreement. Therefore, I urge the court to limit the compensation to 1 million USD so as to not put the claimant in a better position than she would have been if the contract had been performed.
So you admit the liability. That's why you are asking me to limit.
No, Your Honor. In case if the court is convinced by the claimant's arguments, then the court should only allow 1 million USD as per the agreement between the defendant and the contract. But I do argue that there is no negligence from the defendant's side due to the force major event.
Can you please guide me once again to limitation? Where can I find it?
You can find it in clause 4.5 of the agreement.
4.5. Okay, please proceed.
Thank you, Your Honor. Additionally, the claimant's claim for loss of earnings must be dismissed as there is no reasonable degree of certainty. According to Article 11 of DIFC Law of Damages and Remedies, the claimant's loss of earnings must be considered a future loss without a proper estimation and therefore lacks a degree of certainty. I would also like to argue that according to Article 28 and Subarticle 1 of DIFC Law of Damages and Remedies, the defendant is only liable for the losses which is of a kind that a reasonable man with the same knowledge as the defendant could have reasonably foreseen as a consequence at the time of commission the act or omission of the party which committed the breach.
But
In
sorry, at the moment when your sales manager were talking to Miss Artemis, didn't he know that she is a well-known YouTube blogger?
I didn't quite catch your question. Could you rephrase it for me, Your Honor?
So just you are talking about reason about that the damages should be reasonable, right? And you are also talking that it should be within the knowledge of the defendant in case such damages should be reasonable, isn't it?
Yes.
So my question is, when your sales manager were talking to Miss Artemis, didn't he know or she that Miss Artemis is a well-known YouTube blogger?
No, Your Honor. The claimant did not mention anything about her chronic headache or conditions in the history log, medical history log that was provided to the defendant.
Okay.
May I proceed with my submission, Your Honor?
Yes, please.
Thank you, Your Honor. Okay. Um, Okay, in support of the statement I made before, I would like to draw your attention to the Mawson and Mossy and others, which was reported in the DIFC Court of Appeal judgment dated in July 22nd, 2022. Would you like a brief overview of the case, Your Honor?
Yes, please.
Okay, Your Honor. The case highlighted that the consequential losses are not recoverable unless it is directly related to the defendant's action. Here, the loss of earnings should not be allowed as the claim it was not due to the defendant's action that she could not film the YouTube videos, nor was it foreseeable by the defendant. Hence, the loss incurred by the claimant was not direct and certain loss resulting from the defendant's conduct, but rather a consequential loss arising out of an unfortunate event. Therefore, I argue that it is unreasonable and unfair for the defendant to be held liable for negligence as they did not fall below the reasonable standards and to compensate the claimant for uncertain loss of earnings. Your Honor, with this, I conclude my first submission. If you have no further questions, may I proceed to my second submission?
Yes, please.
Thank you, Your Honor. Rather, the defendant did not fail to provide services when, in fact, they offered services within the bounds of the contract. The agreement between the parties stated that the claimant will be provided an opportunity to engage in a solar powered space meditation and yoga sessions. The intention of both parties before the launch was to achieve this purpose. However, the COVID situation was beyond their control, and the defendant did everything in their power to ensure that the obligations to the agreement was met. The defendant's main obligation under the agreement includes medical evaluation, assurance of the safety of participants, and performance of yoga sessions and safe arrival back to Earth. The defendant here conducted a thorough medical evaluation to ensure the safety and fitness of the participants. Furthermore, the defendants also took steps to ensure a safe arrival on the space station and return to Earth, including safety measures in cases of emergency. However, as stated before, the outbreak of COVID-19 on board was beyond the defendant's control. Therefore, I argue that this emergency must be considered a force majeure event under Article 82 as stated before, which rendered the contract non-performable. The defendant was unable to perform their obligations fully under the contract because of the force majeure event of returning to Earth prematurely due to the COVID outbreak on board. Hence, this event must be considered beyond the defendant's control, where they had no way of performing their obligation towards the claimant, that is, participation in the space yoga sessions. Your Honor, I ask the court to keep in mind that the restriction was made in consideration of safety of other passengers on board. Additionally, the defendants tried to mitigate loss by quarantining the claimant and providing masks and gloves to the other participants on board in order to prevent the further spreading of the disease. Thus, I contend that the restriction of the claimant's participation in the program and the defendant's performance of the contract must be considered an appropriate response to the force majeure event while trying to mitigate losses for huge risk and safety of the participants. Hence, highlighting the fact that the unforeseen event being beyond the defendant's control had rendered the contract non-performable. Therefore, it would be unfair on the defendants to compensate the claimant when the obligations of the contract were met. Thus, I argue that the defendant provided the services to the claimant that the claimant had paid for within the bounds of the contract in response to the unforeseen events. This concludes my second submission, Your Honor. In conclusion, Your Honor, for the agreements presented above, the Council contends that the defendant is not liable for negligence and subsequent breach of contract towards the claimant. Hence, the defendant cannot be held liable for 15 million USD, including the loss of earnings. Further, if the court were to allow any compensation towards the claimant, I reiterate that the compensation should be limited to 1 million USD as per the agreement between the defendant and the claimant. Your Honor, I urge the court to carefully consider the evidences and facts presented in this case and find in favor of the defendant. In light of these arguments, if Your Honor has no further questions, I end my submissions here.
Yes, thank you.
Thank you, Your Honor.
So, may I please request senior claimant to have a rebuttal related to claim?
Yes, thank you, Your Honor. The opposing counsels have argued force majeure. I would like to direct the opposing counsels, in Your Honor, to the DIFC contract law, Article 82, and I quote, "Except with respect to a mere obligation to pay, non-performance by a party is excused if that party proves that the non-performance was due to an impediment beyond its control and that it could not be reasonably expected to have taken the impediment into account at the time of the conclusion of the contract or to have avoided or overcome it or its consequences." The law says there are two conditions here for force majeure. So the first one, the impediment was beyond their control. Your Honor, opposing counsels, the impediment was not beyond the control. It was well known that there is a COVID pandemic. Moreover, they were actually testing. The tests were ongoing. So it was within their control to wait for the results of the PCR test. The second condition is that it could not have been reasonably expected to have taken the impediment into account. Not only was it reasonable, they have taken the impediment into account. That's the entire reason why they started testing all the passengers. Therefore, I submit that the opposing counsel's claim for breach of contract is not supported by the law. Thank you.
Thank you. This is the only one argument you want to address?
Yes, that's the only argument I want to address.
Thank you. Can please senior defendant have star rebuttal relating to rebuttal to claim?
Yes, Your Honor. Firstly, I would like to clarify that the unforeseen event here is not the pandemic of the new COVID virus that was ongoing. It is the spreading of that disease on board in the space shuttle where the participants were present. And secondly, I would like to state the recommended practices for human spaceflight occupant safety. Section 6.1, which discusses the medical limits for spaceflight participants. This section does not indicate that a specific medical condition would affect the eligibility of participants in the spaceflight program. However, it does require the medical history of the participants to inform them of the risks that may arise due to their conditions. In this scenario, the claimant is requested to provide her medical history log as per the agreement. And the clause in the agreement do not indicate specific medical conditions that would affect her eligibility. In consideration of this section, it is unclear whether the chronic headache would necessarily affect the claimant's participation or eligibility in the spaceflight program. So there is no specific reason that the claimant did not disclose her headache or she is afraid to disclose the headache. Consequently, the claimant's actions or reasons cannot be justified under the terms of the contract. Moreover, the claimant put herself and others on board at risk by not disclosing and allowing the virus to be exposed to the other persons. Furthermore, there is no specific standardized test for the Vulcan or the new COVID variant virus. So the defendant was sufficient in fulfilling the standards of care
Can I
to.
please request you to stick to the point pertaining to force majeure, because this was the main the force majeure and its effect on validity of the contract overall. I mean, in general, was the question, not actually what precaution measures were undertaken and in general about COVID. Can you please focus on force majeure?
Yes, Your Honor. As stated before, due to the unforeseen circumstances of the COVID 19 spreading on board, the defendants were unable to move forward or unable to perform their contract efficiently. I think with that, I conclude my rebuttal. That is all I have.
Thank you.
Thank you, Your Honor.
Since the rebuttals are over, can I please invite the junior claimant to the junior defendant to present the counterclaim, please?
Yes, Your Honor. Good afternoon. If it pleases the court, I'm Christine Matthew, and I appear as junior counsel for the defendant, Solar Dream Incorporation. Your Honor, I will be addressing the second ground of claim, namely the claimant, Ms. Astrithia's liability to the defendant for a breach of contract stemming from her various conducts. And I will be speaking for approximately 15 minutes.
Please
Due to the
Please proceed.
Due to the aforementioned breach, the defendant also respectfully requests the court to adjudicate damages in their favor, amounting to the sum of $5 million. In support of this, I shall be making 3 key submissions. Firstly, there was a non-performance from the claimant's side resulting from fraudulent non-disclosure. Secondly, misrepresentation was made by the claimant, which led to a breach of contract. Thirdly, the claimant also breached her duty of confidentiality. Your Honor, may I proceed with my first submission?
Yes, please.
Firstly, I would like to draw the court's attention to Article 57 of the DIFC contract law, which states that implied obligations arise from the nature and purpose of the contract, practices established between the parties and usages, good faith and fair dealing, and reasonableness. Should the present circumstances be juxtaposed with the provisions outlined in this article, it becomes readily apparent that the claimant bore an implied obligation to disclose her chronic headaches. To expand further on that, it is imperative to examine each element. 1. It is important to emphasize that space constitutes one of the most inhospitable environments conceivable, where human errors or technical malfunctions are unforgiving. The near absence of gravity, the presence of high-energy cosmic rays, and an inexhaustible amount of complexities inherent to space place considerable demands on the physical fitness and health of travelers. While certain measures can mitigate these risks to some extent, a lingering sense of their presence persists. Consequently, commercial spaceflight missions are described to be dynamic, imposing significant physical demands akin to NASA missions themselves. Participants are faced with substantial suborbital and orbital stresses, necessitating a level of physical stability only achievable by the firmest individuals. Now, looking into the defendant's space retreat, it is apparent that its fundamental purpose was predominantly commercial, intended primarily for entertainment and as an alternative approach to practicing yoga. Although marketed as a once-in-a-lifetime yogic experience to meditate amidst the stars and as an opportunity to draw upon the energies of space and enhance their life force through crystal healing and zero-gravity yoga classes, it would be completely unjust to interpret these claims too literally. Their advertising may be construed as constituting puffery advertisement, a concept initially introduced by the English Court of Appeal in the Carlisle and Carbolic Smokeball case of 1893. Puffery, in a sense, involves the use of exaggeration or hyperbole to promote a product or service aimed at capturing consumers' attention. It is legally permissible provided that the assertions made remain subjective and refrain from crossing into the realm of false advertising. Considering this, the advertising of the retreat was evidently subjective, particularly notable given how it is widely known that both crystal healing and yoga have no scientific evidence of improving physical health. 2. The provision within the agreement between the contracting parties mandating a medical assessment overseen by a qualified medical practitioner, which includes a comprehensive review of the passenger's medical history, is not merely a novel stipulation introduced for the Space Retreat initiative. It relates to a broader standard applicable to all forms of space travel, whether commercial or otherwise. While participants in such ventures may not necessarily be professional astronauts and thus not fall under the regulatory rules governing spaceflight crew members, there still exists a public acceptance regarding the adherence to prevailing medical screening protocols. These protocols are mentioned in the recommended practices for human spaceflight occupant safety, specifically Articles 4.4.1 and 4.4.2. They prescribe periodic medical evaluations by a licensed physician certified in aerospace medicine before orbital and suborbital flights. The main objective is to detect any acute or chronic medical, psychological, or physiological conditions that could compromise the individual's capacity to safely perform or pose a risk to the mission. This is to ensure that an informed decision is made regarding their participation and avoid a situation where they are the cause for an early end of a spaceflight mission. 3. The medical examinations and the necessity to disclose accurate information regarding any existing medical condition were instituted in good faith and fair dealing, as neither party stands to derive any undue advantage or disadvantage thereby. The frequency of the medical examinations and the requirement to disclose was explicitly asked based on occupant safety rather than the mission's success itself. And 4. The reasonableness of a requirement to disclose the chronic headaches can again be traced back to the previously mentioned reasons, which can be briefly summarized as a precautionary measure to look after her safety by understanding her fitness for the flight and make informed decisions. Thus, she had an implied obligation to disclose her chronic headaches during her medical examinations and in her medical history log. Having established this, I would now like to draw the court's attention to
According to what she was required to disclose her medical condition.
Sorry, Your Honor, are you asking me to mention which article is
Yes,
required?
exactly. If it is mentioned in the contract, please guide me to it.
Yes, Article 57. Firstly, Article 57 of the DIFC contract law states that there's an implied obligation to disclose certain information. And in accordance with that, she does have an obligation. And then in the agreement, clauses 5.3 and 5.4 state that she has to disclose any medical condition that could impact her ability to perform in the space retreat safely.
Which goes first, contract or the law in this particular situation?
Sorry?
Which goes first, contract or the law in this particular situation?
In the contract, it was in the contract between the contracting parties, it was clauses 5.3 and 5.4.
5.3 and 5.4. Thank you.
Yes. May I proceed, Your Honor?
Yes, please.
Having established this, I would now like to draw the court's attention to Article 40 of the DIFC contract law. It states that a party may avoid the contract when it has been led to conclude the contract by the other party's fraudulent representation, including language or practices, of fraudulent non-disclosure of circumstances which the latter party ought reasonably to have disclosed. In accordance with this, it can be concluded that the claimant's actions constitute fraudulent non-disclosure, thus depriving the defendant an opportunity to assess her fitness for the flight and make informed decisions regarding her participation. This is also backed up by the fact that her actions contradict the previously mentioned articles 4.4.1 and 4.4.2 of the recommended practices for human spaceflight occupant safety. If the claimant were to argue that she was only to disclose medical conditions that she thought could affect her fitness to participate, that would not be fair or reasonable. To support this, I would like to refer to the FW and Secretary of State for the Home Department case of 2010. Would Your Honor like the facts of the case?
Yes, please.
The appellant, a national of Kenya, appealed to the Asylum and Immigration Tribunal against the decision of the respondent refusing his application for leave to remain in the United Kingdom as a Tier 1 migrant. An immigrant judge dismissed his appeal and the appellant sought an order for reconsideration. One of the main grounds of his refusal was based on the way in which he filled in his application form. Specifically, in the section which asked if he had any criminal convictions in the UK or any country, he said no, despite being convicted earlier for driving under the influence. There was a mandatory refusal of an application where material factors have not been disclosed in relation to the application. The appellant contended that the non-disclosure of conviction was not relevant to the decision because he would have been granted the leave he sought for even if he disclosed it, but he was unable to successfully prove this. The judge, again in the reconsideration, dismissed his appeal with the reasoning that when a direct question is asked and answered untruthfully, there is both a false representation and a non-disclosure, and it is not open to an appellant who gives an untruthful answer to a direct question in an application form to say that the matter was not material. If it was not material, it is difficult to see why the question should have been asked. The present circumstances closely align with that of this case, hence the claimant would be wrong in deciding for herself if a condition was relevant or not. Ultimately, it can be finally tied up to conclude that the claimant's fraudulent non-disclosure of headaches, despite having an implied obligation to disclose, has led to her non-performance in accordance with Article 77 of the DIFC contract law, which provides that non-performance is failure by a party to perform any one or more of its obligations under the contract, including defective performance or late performance.
Can I
Additionally,
please request you to address this case, especially the relevant facts of the case? Why should I be applying this to this very particular situation we are talking about right now?
yes. So in the case that I cited, the main situation was that the appellant did not fill in his application form truthfully. There was a specific section in that application form which asked him to reveal any criminal convictions that he had in the United Kingdom or any other country, to which he replied no. But he did have a criminal conviction in that he was convicted for driving under the influence. Drawing from our circumstances and comparing it to this case, the, the claimant had an obligation to reveal her chronic headaches, especially considering the fact that she had it for 5 years consistently, but she still did not reveal it in the medical examinations or in the medical history log. So even if she did think for herself that it wasn't relevant to the space retreat, it would be wrong because it is not up to her to decide that.
Noted. Thank you.
If Your Honor has no further questions, may I proceed with...
Yes, please proceed.
Additionally, this can also be supported by Article 113 of the DIFC contract law, which in summary gives that the non-performing party bears liability solely for the damages reasonably foreseeable at the time of contract formation resulting from such non-performance. Evident from the claimant's actions and thought process, her non-disclosure could have and was reasonably foreseen to impact her ability to participate in the retreat safely. Your Honor, may I proceed with my second submission?
Yes, please.
Article 29, subsection 5 of the DIFC Law of Obligations state that non-disclosure cannot amount to a representation unless the non-disclosure is a breach of a specific duty to disclose. It is safe to confidently say that the claimant had an evidence-specific duty to disclose her ailment, since it was explicitly stated in the agreement, which was mutually signed by both parties, that the passenger declares and represents that to the best of their knowledge and belief, they are not aware of any medical condition or symptoms that may affect their fitness to participate in the spaceflight, and that they acknowledge the importance of providing accurate and complete information during the medical evaluation. Also, upon examination of Article 30 of the DIFC Law of Obligations, it is apparent that both the claimant and the defendant's situation accurately aligns with each element of this article. The article states that a person is liable for misrepresentation to a representee if he is the representer in relation to the misrepresentation. The representee has entered into a contract after the misrepresentation has been made. The misrepresentation influences the representee to enter into a contract or affects the terms upon which he agrees to enter into it, and the representee suffers loss as a result of entering into the contract. Additionally, a similarity can also be drawn from the Salem Dweller and Damat Park Towers Company case of 2020. If it is all right with Your Honor, might I very briefly state the facts of the case to bring about the similarity?
Yes, please.
In this case, the claimant concluded a sale and purchase agreement with the defendant. The claimant claimed there was a misrepresentation about three particular matters: the state of readiness of the development and the likely completion date, the size of the unit, and whether the unit had a pool view. The claimant contended that he was assured Park Towers was near completion with specific unit details, which was what led him to enter into the SPA in the first place. This case defined misrepresentation as when a party to a contract makes incorrect statements of facts to induce the other party into entering into an agreement which would essentially result in a loss for them. In the present scenario, it was through the claimant's clear misrepresentation through non-disclosure of circumstances on multiple occasions, which should have been reasonably disclosed, that the defendant boldly entered into a contract with her. And therefore, effectively, this misrepresentation was a clear breach of contract. Your Honor, may I proceed with my final submission?
Yes, please.
It is both a said and an unsaid thing that every contractual relationship, especially that of a commercial setting where one stands to gain or lose, has an express or implied duty of confidence. Article 29 of the DIFC contract law provides that where information is expressly given as confidential by one party in the course of negotiations, the other party is under a duty not to disclose that information or to use it improperly for its own purposes, whether or not the contract is subsequently concluded. Where appropriate, the remedy for breach of that duty may include compensation based on the benefit received by the other party. Express here does not necessarily have to be taken as explicit wording. It can also be taken as an implication through the nature of the information itself. Applying this, a breach of confidentiality may occur if one party divulges contract-related information without prior consultation with the other party, particularly if such disclosure results in one party's gain and the other's loss. In this case, the claimant violated her duty of confidentiality by publicly sharing details of the retreat's events and mishaps on YouTube without consulting the defendant. While it's true she may have felt compelled to share her experiences with her audience, she should have prioritized any contractual obligations regarding confidentiality and consulted with the defendant before sharing the information. Furthermore, the improper use of this information benefited the claimant as it led to public sympathy and consequently tarnished the defendant's reputation. For these reasons and the ones stated by my co-counsel, I urge the court to find in favor of the defendant, Soladim Incorporation. If Your Honor has no further questions, that concludes my submissions for the second issue in the proceedings.
Thank you. Does the agreement prescribes any confidentiality clause?
Sorry, can you repeat that for me?
Does the agreement specify the confidentiality clause made
No.
between the parties? No. Okay.
No, the
Thank you.
agreement.
May I please request the junior claimant to present a defense to counterclaim?
Yes, thank you, Your Honor. If I may begin.
Yes.
Your Honor, opposing counsel, good morning. My name is Karim Khazal. I represent the claimant, Ms. Astrodia, and I will address the merits of the counterclaim. Your Honor, the opposing counsel felt it necessary to share that there's inherent complexity and high levels of risk involved with space travel, and we do not dispute that. However, the claimant's non-disclosure of her symptoms does not necessarily impede that. It was not necessarily a breach of any contractual obligations. Your Honor, this reading we will show you that the agreement only obligated disclosure of symptoms to the extent that they affected the passenger's fitness for space travel. And then you will also come to learn that Ms. Astrodia truly believed her symptoms would not affect her fitness for space travel. It is because of these two facts that the case should be swayed in favor of the claimant. And additionally, the subjectivity of Ms. Astrodia's beliefs was contractually valid, as it was consistent with the opposing counsel's rhetoric that the flowery language used, such as the driving of the life force, was to be interpreted in a subjective manner. And so, against this backdrop, I will make two submissions. First, that the claimant did perform all of her contractual obligations and that her non-disclosure was reasonable in the circumstances. And second, that the claimant did not breach any duty of confidentiality by disclosing her experiences on her YouTube channel, because she had no contractual obligation to keep anything confidential, and because she was allowed to film during the mission. Now, turning to my first argument, the claimant performed all of her contractual obligations, Your Honor. She paid every installment of the ticket price. She underwent 2 mandatory medical examinations, and she quarantined for 2 weeks right before the flight. However, the non-disclosure of her symptoms did not breach the obligations under clauses 5.2 to 5.3 of the Space Flight Agreement for 2 main reasons. First, yes, 5.2
and
5.3. If I may direct your attention to 5.2,
yes,
it obligates disclosure on the passengers to the best of their knowledge and belief, and only regarding medical conditions or symptoms of a potential condition that may affect their fitness to participate. Now, while the opposing counsel contends that this is an unfair standard to impose on the defendant, and that it should be interpreted in an objective manner, again, this is inconsistent with the rhetoric that there should be subjective interpretation of some clauses and an objective interpretation of other clauses. There should be one uniform standard. And to support this, Your Honor, it is fair to impose this standard, because at the end of the day, Solar Dream is a corporate entity. They are responsible for the interpretation of their own contractual provisions, because they are responsible for drafting them. If it is reasonable for a person to read those and interpret those provisions as being subjective, then they should be held against that standard, and not the claimant, who is merely a YouTuber with no real legal background or experience. And so, to develop this further, Your Honor, when interpreting this clause in its plain language, we see that the defendant was only concerned with the kinds of symptoms or ailments that would affect the passenger's fitness to participate. And that is the understanding a reasonable person would have.
Any backup of the same argument with the legal authorities?
Yes, Your Honor. Article 49.2 of the DIFC contract law specifies that, subject to 49.3, if an intention cannot be established, the contract shall be interpreted according to the meaning that a reasonable person of the same kind as the parties would give it in the same circumstances. In this case, there's a dispute about what is the common intention of the parties. And so we need to apply the reasonable person standard according to the DIFC contract law. And a reasonable person in the circumstance of Mrs. Strodia would read the word belief to mean something subjective, right? And so in that light, we need to consider the nature of her symptoms. If I may direct your attention to page 4, paragraph 5 of the record, Your Honor.
Just a second. Paragraph 4 of
page 4 of paragraph 5, Your Honor.
Okay.
Yes. It says, despite her healthy lifestyle over the past 5 years, she has suffered chronic headaches, and despite seeing a number of doctors and trying various alternative remedies, she has not been able to stop them. Now, due to the failed attempts to cure those headaches, it was reasonable for her to believe that they were not medical in nature. And also, they did not stop her from being able to practice yoga and to travel around the world, both of which are very physically intensive activities. Additionally, from its language, the contract accommodates for subjective belief, Your Honor. And if we look at page 4, paragraph 6, it says that Artemis was convinced that her headaches were caused by a misalignment of her neurons with the Earth's gravitational field. And the key word here, Your Honor, is convinced. And she was entitled to that. And so, second, while her symptoms did return before the flight, it was still reasonable for her not to disclose. Your Honor, page 6, paragraph 9 of the record. It reflects that the return of the headache was not uncommon for her. And additionally, when she arrived at the facility, she experienced some fatigue, which could have reasonably been attributed to all the travel to a facility where she arrived at 5 in the morning. If I may share a personal anecdote, Your Honor, I live in Qatar, and I once traveled to the UAE, and the very next day I began experiencing some fatigue and sensitivity in my eyes. And that's a very, very short trip. Imagine what someone traveling from Montreal to Dubai would experience. And so we would like to put forth that this was reasonable for her in the circumstances. Additionally, Your Honor, COVID was not on her radar. She quarantined for 2 weeks, and then she conducted a lateral flow test, which, according to the professional nurse, returned negative and was sufficient to rule out the possibility of COVID. Again, reasonable in the circumstances, Your Honor. And therefore, to conclude my first argument, the claimant could not have foreseen that her non-disclosure of the symptoms would amount to fundamental breach, given their non-medical nature and all the steps that she willingly took to mitigate that risk.
But if we address the fact sheet, wasn't this headache something different that was Miss Artemis experienced?
It may have been slightly different, Your Honor, to the extent that it was a dull ache, but again, it was not uncommon for her. And given all of the changes that she was experiencing, a new environment, a lot of physical strain, and the nervousness that comes with the opportunity to fly into space, it would be reasonable for this to label this as just an extension of her already existing symptoms, Your Honor.
Good to know. The question for me is, you're pretty straightforward said that COVID-19 was not on her radar, but if we will look into the overall history, isn't it common for the people expecting to fly somewhere to be cautious about this disease, especially if you understand that you will have to quarantine for at least 2 weeks and be cautious about it? Like I'm just wondering if the headache was the common symptom for COVID-19 in the circumstances for this particular virus, or no?
Your Honor, it is true that the headache was a common symptom of the COVID virus, but we have to treat the claimant's case as an exception because her circumstances were different. You are right in that people traveling to different parts of the world when there's a COVID pandemic going on should take reasonable steps to ensure their own safety. And she did. She quarantined and she took a lateral flow test. The the lateral flow test might not have been 100% conclusive, but it did return negative as it did for the rest of the passengers. And so she had reason to believe that she was fine. And when we pair that with the fact that she has a history of suffering chronic headaches that are not medical in nature, then we start to see why it was reasonable for her to label this off. Because, Your Honor, at the end of the day, she was the one that had a lot to lose on the line. According to the contract, clauses 3.3 and 5.2, the defendant had the discretion to delay the flight if they saw any reason to do so. Unfortunately,
Sorry, the defendant had the discretion to delay the flight.
Yes, the defendant had the discretion to delay the flight. Unfortunately, the claimant did not have this discretion. She did not have this power. So she felt like she had no choice but to board the flight. Because if she had refused to do so, then the money she had already invested would not be returned to her. And may I proceed with the second point, Your Honor?
Yes, please.
The second argument is simple. There were no contractual obligations on the claimant to keep any of the information confidential. She was free to film her experience, and that is in the answer to the clarification questions, Your Honor, page 3, paragraph 2.
Paragraph 2.
It says there were no restrictions in safety protocols or otherwise on filming.
Okay.
We see that she had the freedom to share her experience and no real obligation stipulated in the contract to keep any of it confidential. And for those two reasons, Your Honor, she cannot be found in breach of contract because she did everything that was reasonably expected for her, and her subjective beliefs were valid given the way this contract was drafted.
Doing very heavy reliance on the factual background, can you please guide me through the legal canvas that can support somehow your arguments?
In reference to the DIFC contract law, Your Honor?
In reference to the authorities in general, whenever you will find fit.
Your Honor, we can look to, if I may have just a moment.
Especially, I'm interested in the questions of misrepresentation and confidentiality.
As for the misrepresentations of confidentiality, Your Honor, unfortunately, I do not have any reference to make to the DIFC contract law. But we can
and pertaining
look
to the agreement itself.
Only the defendant had an obligation of confidentiality, which is in 5.6, and that only regards to the medical information during the evaluation.
Noted, please proceed.
With that, Your Honor, I conclude my pleadings, and I'm in your hands if you have any further questions.
That's fine. May I please request the junior defendant for rebuttal relating to the counterclaim?
Thank you, Anand. Firstly, I would like to draw back the court's attention to my first submission. In accordance with Article 57 of the DIFC contract law, the claimant did in fact have an implied obligation since the situation called for it. The defendant's argument that her obligation to disclose this was not of essence of the contract would also not stand, and there are two reasons for this. Firstly, Though Clause 5.2 of the agreement did in fact state that a passenger requires to declare and represent to the best of their knowledge and belief that they are not aware of any medical conditions that may affect their fitness to participate in the space flight, the circumstances surrounding the medical history log was different. For the log, she was explicitly asked to list out all ailments that she suffers or previously suffered from. That clearly included anything and everything, whether she thought it was relevant or not. Second, the Federal Aviation Administration also provided the public with a special guide for medical examiners specifically. The guide gives a clear-cut map as to how to undertake each applicant's medical history. Item 18 of the same guide explicitly states that the applicant should report frequency, duration, characteristics, severity of symptoms, neurological manifestations, and whether there have been any treatments or side effects. And all this is being referenced specifically to headaches itself. Additionally, item 46 also states that participants suffering from headaches without an injury or condition would require temporary disqualification during periods when the headaches are likely to occur. Hence, her disclosure was of essence of the contract, and in not complying, there was non-performance. Regarding the defendant's advertisement, it cannot be taken as a representation. Guiding the court back to my first submission again, the purpose of the contract was predominantly commercial, intended only for entertainment. The advertisement was clearly puffery advertisement, a marketing strategy used by many commercial entities. Besides that, it is also, as stated before, widely known about the lack of scientific evidence to back up crystal healing or yoga improving physical health, and that information would have been available to the claimant also. Additionally, the defendant could also not have been able to advise the claimant otherwise because she never revealed her intention to join the retreat or ailment in the first place, and that was not something the defendant could just assume. Finally, regarding confidentiality, I would like to draw the court's attention back to my third submission regarding confidentiality. It's true that the claimant did have permission to record whatever is happening inside the space retreat, but she didn't have the authority to release any contract related information. The situation at hand was one that went outside of either party's expectations due to the claimant's action itself and was left in uncertainty with it yet to be straightened out. Thus, there is a clear implication of confidentiality here due to the nature of the information revealed. And with that, the defendant also suffered losses due to her breach of confidentiality.
How would you address the issue of difference between the bargaining power that was trying to be invoked by the defendant? In this particular situation, he is claiming that Mirza Artemis is just a YouTuber who is not a lawyer, who was going through the contract and who would not understand fully the legal terms, etc.
First of all, the claimant in the agreement, she would have been submitted an agreement before signing. She would have clearly read out in there that was supposed to reveal any medical conditions that are required to assess her fitness for the space retreat participation. In accordance with that, she didn't reveal anything despite having a chronic headache for 5 years. And that's not something that we as a defendant could also assume and take into consideration. Therefore, even as a YouTuber, there's not really any legal background required for that. Any reasonable person could understand that it is necessary to disclose any condition, especially one that has been going for 5 years consistently, would have to reveal it to the medical examiners in order to assess her fitness and her safety.
Noted. Thank you. Can I please request the junior claimants for rebuttal relating to rebuttal to counterclaim?
Thank you, Your Honor. Your Honor, we do not dispute that the claimant had suffered a chronic headache for 5 consecutive years. However, what we are trying to set out is that these chronic headaches, at the end of the day, did not prevent her from practicing in physically intensive activities such as yoga and space travel. Additionally, Your Honor, even if the court is not convinced that her non-disclosure did not amount to a non-performance, we would like to set out that at the end of the day, the non-performance was not fundamental in nature. And so Article 86.2 of the DIFC contract law sets out 4 criteria that make a non-performance fundamental in nature. A party can only rely on the fundamental nature of a non-performance to terminate the contract the way that the defendant did. And so the first way is the non-performance substantially deprives the aggrieved party. Second, that the compliance with the obligation is essence to the contract. Third, that the non-performance was intentional or reckless. And fourth, that it gives the aggrieved party reason to believe that it cannot rely on the other party's future performance. Your Honor, the commentary on the Unidrot principles, which the DIFC contract law are based on, illustrate that these 4 requirements should only be taken into consideration. They do not necessarily outweigh each other, and the non-fulfillment of one does not necessarily make a non-performance fundamental. And so with that, we present that the non-performance did not deprive the defendant from what they were to expect, because at the end of the day, she paid all of her contractual dues. And for that same reason, because she paid all of her contractual dues and did every other obligation, then they could not have had a reason to believe that they can't rely on her or that she is not to be trusted to perform in the future. Additionally, the non-performance was not intentional or reckless in the sense that she didn't know how to interpret the contract in any other way besides the subjective intent. And so in her own mind, she was doing what was right. And to support this, Your Honor, Professor Eckhart Broderman of the University of Hamburg also provides an expansive commentary on the Unidrot principles. He has said that in interpreting 86.2, the attribution of fault is only relevant in the context of characterizing a non-performance as fundamental, and that courts ought to consider contributory actions from the obligee. So if the court were to attribute fault to the claimant for that non-performance, then they must also consider contributory actions by the defendant. And a contributory action in this case is the fact that they did not wait for the PCR test, despite having every contractual remedy available to them and the discretion to delay the flights with all the risks that the passengers knew were involved and the opportunity to set a future date. And so and to conclude my rebuttal, even if the claimant's non-disclosure was a non-performance, it was not fundamental by the meanings of 86.2, and so she is not in breach of contract. Thank you.
Thank you. I'm thanking the parties for presenting their submissions, and I believe that now hearing came to the end. If the case manager can suggest me if we have any further steps to conclude.
Hi, Anastasia. No, there aren't any other steps beyond this.
Therefore, I thank again the parties for their submissions. It was really very interesting. It was very challenging, and honestly, it was amazing from both parties. You all made very good job, and you should be proud of yourself because actually it's a lot of work behind. Thank you a lot.
Thank you, Rana.
Thank you. Congratulations,
Bye.
everyone.
Fun participating in this session with you.
Yeah, I hope like you had interesting experience because this is actually how the hearings are conducted, and further, if you will decide to go to the courts, actually like probably you will have nastier judges than me who will be grilling you on each and every point. So at least now you have better understanding how to react. So I'm thanking you all once again, and best of luck for the next rounds.
Thank you, Rana.
Thank
Thank
you.
you.
Bye.
Have a good